The next session is Sedition and the Spectre of the Anti-National. Our panelist is Mihir Desai, and the session will be chaired by Uday Narkar. Can we please have the panelists on stage? Mihir Desai is a human rights lawyer and a senior counsel practicing criminal law in Mumbai. He is also the co-founder of Human Rights Law Network, which provides free legal services to those with little or no access to the justice system, conducts litigation in public interest and engages in advocacy. Mihir also has that enviable reputation of being everyone's friend in the broad left, which is a serious reputation. And that's because this business of criminalization of dissent is not a new one. So when in trouble, remember Mihir, and in his inimitable Bindas Bhai style, he'll set all your worries to the wind. Uday Narkar, our chair for the session, is a translator, teacher and media producer, and he will take the proceedings on. I invite Mihir to take the podium. We have 20 minutes for the speaker and 10 minutes for question and answer.
Thanks for inviting me here. I'm going to speak on a topic which competes with some of the postmodernist writings as far as inaccessibility is concerned. That is law. I'll try to divide what I'm going to speak in three parts. One is, of course, the history of how sedition law has developed in our country over the last century and a half. Second is, what do we make of the charges against Kanhaiya and the others? We shouldn't forget the others also. The charges against Kanhaiya and the others about sedition, how do we look at them? And third is, what is the solution as far as the law of sedition is concerned? Let me start with an incident which happened in 1921. In September 21, the British government came across 3 articles of Gandhi written in the magazine called Young India, which he was editing, and of which the publisher was one Mr. Banker. He had written articles basically telling the people that you should spread disaffection against this government. It is your duty to spread disaffection against the government, and then criticizing the Jallianwala Bagh, various other things. There was a debate within the British Empire as to should we not charge him with sedition for what he has done. Let's put him behind bars. At that time, the call taken was that, look, at the moment, his popularity is quite high. If you put him behind bars on grounds of sedition, it is possible that his popularity may increase even further. So this is not the right time. The non-cooperation movement was going on, etc. On 10th March, in February 1922, February 22, the Chauri Chaura incident happens. The non-cooperation movement is called off by Gandhi. There is a debate, there is a dispute, there are murmurs of dissent in the Congress and a number of other people saying that, look, this is wrong thing to call off the movement. A lot of people opposed Gandhi at that point of time. And the British Empire said that now let us strike. Now let us sue him with sedition. Now let us put him behind bars for sedition. He is already discredited, according to them. He was discredited. So let's charge him now, and let's use the trial against him to propagate our views as to how we have been governing the country and how we are nice for the country, etc. Let's use that trial. So in February, Chauri Chaura happens, non-cooperation movement is called off, and in March 1922, he is arrested under sedition. Gandhi is arrested for sedition. This, according to me, was what I would like to call the Gandhian blunder of the British Empire. Chapter 1, Gandhi is called to court. The trial takes place in Ahmedabad. Gandhi is called to court. He is asked by the judge that, Mr. Gandhi, what is your profession? He was a writer and he was a politician. He said, I am a farmer and a weaver. What? We thought you write and you are a politician. Serving my people, I do not call a profession. So that's point first day. Next day, the charges are to be read. Charges are read out. Section 124A, you have spread disaffection against a country, against the British Empire, etc., etc. You are guilty of sedition. What do you have to say? Assumption was he will say, no, I am not guilty, and the trial would start, which would then go on, and then British Empire will come and show how great it was, etc., etc. Gandhi says, I am guilty. I am guilty of everything you say. I have committed. Yes, I have done everything you have said. The public prosecutor, who was Advocate General of Bombay, says that, no, you must conduct the trial. So the judge says, how can I conduct a trial? Now man is pleading guilty. What trial? So the trial collapses. Third day, Gandhi is called for sentencing hearing. That what sentence should be awarded to him. And this is what Gandhi says. It's one paragraph I would just like to read out in a long way. He said, Section 124A, under which I am happily charged, is perhaps the prince amongst the political sections of the IPC, designed to suppress the liberty of the citizens. Affection cannot be manufactured or regulated by the law. Section 124A says, spreading disaffection against the government amounts to sedition. So he says, affection cannot be manufactured, regulated by the law. But the section under which we are charged is one under which mere promotion of disaffection is a crime. I have studied some of the cases tried under this, and I know that some of the most loved of the Indian patriots have been convicted under it. I consider it my privilege to be charged under it. I hold it a virtue to be disaffected towards a government which in its totality has done more harm to India than previous system. Holding such a belief, I consider it to be a sin to have affection for the system. This is what he says. And he further says that, look, he tells the judge. The judge says, yes, but what about the sentencing? He says, look, you have two options, he tells the judge. Either you resign, or you punish me with the severest penalty, and which is life imprisonment. Okay, you punish me with the severest penalty you can give under Section 124A. These are your two options. I leave it to you. Yes. So judge, of course, doesn't resign, but he gives a 6-year punishment, 6 years imprisonment. But in his judgment, he says that, look, I have no option but to punish you, so I'm punishing you. But I hope, and I'm recommending to the government, that if they feel fit, they should release you. Yeah? And I will be the most happy person if they actually release you. This is what the judge says in his judgment. And so the whole British Empire game plan of trying to create a spectacle out of the trial in their favor collapses. That's why I call it a Gandhian blunder of the British Empire. The present Kanhaiya case is a repetition of the Gandhian blunder. By Mr. Modi, Mr. Shah, Mr. Singh and Ms. Irani, who had they read history and not mythology, would have learned their lessons. But जैसे एक महान व्यक्ति ने कहा है कि कुछ लोग ऐसे होते हैं जिनकी उम्र तो बढ़ती है, समझ नहीं बढ़ती. This is Section 124A. Let me just go back a little. let me go back a little bit into legalities because I'm a lawyer, I'm supposed to talk more about law. Macaulay formulated the draft penal code way back in 1820s and 30s. And in that he had a section 113 which was a replica of what is section 124A today of the Sedition law. In 1860, after the British Crown took over, after the national struggle, independence struggle, first independence struggle, the 1860, the Indian Penal Code is formulated, brought into effect. For some reason, sedition doesn't find a place in that. It's a copy of Macaulay's draft, but for some reason, doesn't find a place in that. There are lots of research done as to why it did not. I'm sure some JNU people must have also done research why this place was, why 124A was not included. Whatever may be the reason, in 1870, after 10 years, they amended the law and bring in 124A. That's why it's called A, because it was brought in, it was not in the original thing, it was brought in later on. And broadly, what in a very simple language, what the law said was spreading disaffection towards the government would amount to sedition, for which you can be sent behind bars for life. This was basically what this is in very simple language, this is what the law says. You can't spread disaffection against the government. For a couple of years, nothing happened. Then in 1897, Tilak, Bal Gangadhar Tilak, who was at that time editing two papers, Kesari and Maratha. Kesari was the Marathi paper, in which he wrote, there was a plague in Bombay, Maharashtra, Bombay Presidency at that time. A lot of people had died. He had written very critical articles about the way the government conducted itself in controlling the plague. 2 plague inspectors were killed. Tilak was charged with sedition, saying that you said all this about plague inspectors, etc., etc. That's why. And then he had written something about Afzal and Shivaji and all that kind of thing. And so he was charged with sedition. That was the first very important case of sedition which happened. Matter went on for a long time. He pleaded not guilty. He said, I have not spread any disaffection towards the government. This is what I have said. There is nothing which amounts to disaffection. He was convicted by an interpretation of the law which was even more broader than what the section itself provided, which said that spreading disloyalty, hatred, contempt, etc., anything towards the British government would amount to sedition. And you have done that, so you are convicted of sedition. He was convicted of sedition. Sent to prison. After 10 years, after he comes out, there is a bombing in Muzaffarpur, where 2 persons die. He writes an article in Kesari saying that yes, people have died, it's sad, but please try and look at the roots of the terrorism. Why are people throwing bombs? Look, unless you try to attack the roots, you will never be able to stop it. So he's again charged with sedition. This time, the person who represents him is Muhammad Ali Jinnah. Jinnah is his lawyer, Tilak's lawyer. He and Tilak have a dispute. This is a normal dispute which we have between lawyers and clients. Jinnah said take a particular approach because it will save you in court. Tilak says forget it, I am going to take a political approach. It happens many times with people like me also. I mean, for instance, if a dam is being constructed and a person comes to us, you first try and say that let's see, rehabilitation should be there, etc. No, nothing doing. The client would say nothing doing. We want the dam to be stopped. There is no. You say, but legally, how? You say, forget legality. This is what our point is. You want to argue it in court, otherwise forget about it. And that's a right. I mean, and as human rights lawyer, we have to respect that. Muhammad Ali Jinnah was not a human rights lawyer, at least at that time, and so he had a disagreement with Tilak. And he said, so Tilak said, okay, you go, I'll argue my own case. So Tilak argued for 6 days. Didn't make much headway, and he was punished. At the time when he was punished, he was sentenced to again some 6 years, 5-6 years of imprisonment. For sedition he was punished. He said very clear, he said something. He said basically, possibly the powers that be prefer that my brethren will be more benefited by my being inside the prison than being outside, and that's why this is the punishment which is afforded to me, etc. He makes a speech. That speech, if you go to the High Court, Bombay High Court, on the 2nd floor, in the court in which he was convicted, outside that court there is a plaque giving a speech. It's one of the rare instances anywhere in the world where the person who was convicted, his photograph is inside the courtroom. His speech is outside the courtroom. It's a rare, I mean, it's quite a rarity. So Tilak was, then came Annie Besant's trial. Okay? Then came Gandhi's trial. Okay? Various other trials. Okay? But basically, before the independence, any spread of disaffection towards the government was treated as sedition. You could be punished for it. This was the law. Constituent Assembly came in. They were deciding that freedom of speech and expression should be a fundamental right. That fine, freedom of speech should be a fundamental right, but there should be some reasonable restrictions to it. So what should be the restrictions? So one of the restrictions was defamation. The other restriction was contempt of court. The third restriction was security of state. The fourth restriction, which some people wanted to bring in, was sedition. That sedition should be a restriction on fundamental right to speech and affection. Kanhaiya Lal Munshi and various other people said, sorry, we can't have sedition as an exception to freedom of speech and expression. And they opposed it, and therefore in the constitution, okay, in the reasonable restriction clause to freedom of speech and expression, you do not find this particular clause of sedition as being an exception. But Constituent Assembly was looking at constitution, it was not looking at IPC. So IPC continued anyway, that is 124A. That continued anyway, but in the constitution they didn't bring it. In 1950, 2 strange bedfellows were charged for violating various laws. One of them was a magazine called Crossroads, where Tamil Nadu government, run by the CPI person there, Thapar. CPI was banned in Madras at that time, and Thapar's thing was confiscated, and he was basically charged with violating freedom of speech and expression. Simultaneously, Delhi government took similar action against organizer, okay? That is RSS mouthpiece. Okay? This went to court. Court said that you can't stop these people because security of state is one thing, law and order is another thing. Security of state is a reasonable restriction. Law and order is not a reasonable restriction, as defined under the constitution, and therefore you have to lift the ban on these papers. So the ban was lifted. So Nehru moves the first amendment to the constitution, wherein reasonable restriction, which up till now was defamation, security of state, etc., to the freedom of speech and expression, was now included also security of state. Even at that time, a move was made to include sedition. Okay? But Nehru said that no way, sedition is something which we will not tolerate. We will not tolerate it as a legal principle, and so we will not have it in our constitution. Taking some lessons from this, in 3 different high courts, the law of sedition, 124A, was challenged as being unconstitutional. The 3 high courts struck it down, saying that this is unconstitutional. In a democracy, you can't have this freedom and this sedition as a law. The matter went to Supreme Court. Yeah. Matter went to Supreme Court. the Supreme Court said that the clause is valid, but you will have to read it in a diluted manner. And what is the diluted manner? That mere spreading of disaffection towards the government, disloyalty towards the government, is not an offense, is not sedition. It should also lead or have a tendency of leading to incitement to violence or public disorder. So unless both are together, so this was the difference between what the pre-independence law is and today's law is. In the earlier legislation, there was nothing which, I mean, even if nothing incited violence, nothing incited public disorder, the fact that you speak itself amounts to sedition if it spreads disaffection. Now the law is that no, you have to incite disaffection towards the government, you have to incite violence, etc., etc. Then only it will amount to sedition, not otherwise. It is in this and similarly, subsequently, like in 1984, after Indira Gandhi's assassination, there were 3 Sikhs who shouted slogan, Raj Karega Khalsa, Khalistan Jindabad, etc., etc. They were charged with sedition. They were charged with sedition. The matter went up to Supreme Court, and Supreme Court said that, look, this kind of slogan shouting and all, you can't call it sedition. People are shouting slogans, that the energies are high, people are shouting slogans, and acquitted those people. Okay? So slogan shouting was not treated as something which, mere slogan shouting is not something which you brand people with sedition for. So this is how the law is developed. Only, I have just 2 or 3 minutes more. Okay. If you look at the judgment, see, what I am shocked about the present situation and what has happened to Kanhaiya, etc., is that this was a case where let's not get our attack diluted by whether he shouted these slogans or whether he did not shout these slogans. That's not relevant. Even if he shouted all the slogans which he is supposed to have shouted, he has still not committed sedition. That's the point. That's the point. Even if you say whatever he is supposed to have said, you may or I may disagree with it. That's a separate issue. But if you have shouted those slogans, okay, unless it has led to incitement of violence against the state. I was handling this, just last thing and I'll finish, I was handling this case of Asim Trivedi, who was a cartoonist, who was charged with sedition. And he was put behind bars immediately, he was arrested. And the Chief Justice of the High Court at that time, suo moto, took action and released him on bail. Okay? Released him on bail on the next day. Okay? I would have expected the Supreme Court and the High Courts to have done that. Let's be clear, let's not shy away from criticizing our judiciary when we are criticizing the executive and the legislature. Let's not shy away from doing that. I mean, look at the judgment of the Delhi High Court. Amputation, gangrene, I mean, is it a medical speech or is it a judgment? Gangrene is required, but it's required in 124A. There are some people who are saying that 124A can be diluted, can be read down further, this, that, and no. Okay? These laws are not passed for convicting people, remember that. The anti-terror laws, the special laws are not passed for convicting people. These laws are passed basically to put them behind bars and have a chilling effect on people speaking out. The purpose of these laws is not that hardly anybody gets convicted under these laws. But nobody's bothered because you put them behind bars, 10 other people will keep quiet. That's the idea of these laws. And therefore, whether somebody is convicted or not convicted is not something which we have to look at. We have to see the misuse or actually the real use of these laws, which is for the purpose of silencing critics, silencing criticism. And that is why it's most important that we don't talk about diluting these laws and whittling down and reading down. 124A has to go. It has gone in UK, where we have, from where we borrowed, not borrowed, UK brought in this law. This is the same thing as 377, please remember. Okay? UK abolished it. Indian government still doesn't want to abolish it. Same thing, sedition, UK abolished it. There is no sedition law because there are other avenues open under the Indian Penal Code to prevent people from inciting violence, etc. There are enough other provisions of the law. You don't need sedition for that. And that's why and let me just end by saying that ultimately we need our demand from the collective. The demand should be not to dilute, not to whittle down, but to amputate this particular provision, okay, that is 124A from the Indian Penal Code. Okay. Also, the last thing is that while we talk about Kanhaiya, I hope and wish that equal energy is put in the other persons who are in jail, including Gulani and the others. And let's hope and let's fight for the release and quashing of the charges. Thank you very much.
We have time for 3 questions and the chair's comments.
Yeah, I'm reminded that I'm here just to moderate the discussion. And we have just 5 minutes, so three questions, quick questions. No questions? You're making my job easier. We have still some time. Anybody? At the end. Yeah. One at the end, the lady. Yeah.
Hello, my name is Girija. I had a question about this judgment on awarding bail to Kanhaiya. Wasn't the judge already prejudging the issue in her order for the bail? And can any action be taken against the judge for having exceeded the brief? Thank you.
First, answer to your first question is yes. Answer your second question is, historically it has been very troublesome taking action against judges, unfortunately, in the sense that you can go in appeal and try to have it reversed in the appeal, etc., etc. But reversal in the sense that ultimately you got bail. Okay, so a person who has been released on bail also will think 10 times before going higher up, because higher up can also overturn that part. So they will be a little cautious about that. But I definitely feel that this whole talk on nationalism, etc., given in the and assume, because what will happen is this judgment will affect the other people's bail, because she has already commented upon the kind of she has already commented upon the nature of the slogans, etc., etc., and gone into a tirade about nationalism and anti-nationalism, etc., which she had no business to do. That's what I feel.
Can I ask a question? Upstairs. Hi. Yeah, I just wanted to ask about this law being applied to artistic practices. For example, the artistic interpretation of the map of India, for example, will that be a seditious act, or how when you look at the very known Hussain case? And later on, if we were to, use statements or words that might be seen in disaffection to the flag or any kind of symbol of the state. So I want to know how that is interpreted, specifically in that sense, and can it be seen as sedition in any manner or such? Yeah.
Well, if by the time you reach Supreme Court, the Supreme Court won't treat it as sedition. But by that time, you would be in jail for some time. See, the problem is that a problem with our system is that the police and the lower judiciary, especially, also the higher judiciary, but police and the lower judiciary, I mean, you are arrested, like it happened with Asim, okay? Or like it has happened, I mean, I can give you kind of cases, kind of instances where sedition has been filed. I mean, one person said that Mr. Modi was responsible, an editor of a paper, for floods in Surat, and he was charged with sedition, put behind bars. Yes, I mean that's a real case. Okay? Another person wrote about Kandamal riots, and he was charged with sedition. So the problem is ultimately yes, you might be acquitted. Ultimately, nothing will happen to you, etc. But then, in the ultimate analysis, we are all dead anyway. So that way, the point is, unless you remove this law today and now, it is going to be misused. It shouldn't be. The fine legal interpretation, philosophical interpretation by which this doesn't amount to sedition, whatever you are saying. Okay? But by the time you convince a court, you would have been roughed up already, that time.
I think that's all the time that we have for the discussion, and we really enjoyed.
Last question.
One more question? One last question? Okay.
Last question.
Yeah, last question over there.
You made a reference to the Supreme Court stating that this law needs to be seen in its diluted form. So when was this judgment or directive given?
Sorry?
You made an observation. You just said that the Supreme Court had made an observation that this law needs to be seen in its diluted form. So when was this observation made?
It was based in 1962 in the judgment of Kedarnath, okay, where the Supreme Court observed that it should be seen in a light. And also remember, just one last thing, just to give this thing, the notion of freedom of speech and expression is changing in our country. Legally, I'm talking, otherwise also it's changing, but legally also it's been changing. You should read Shreya Ghosal's judgment of the Supreme Court given in 2015, where Supreme Court makes three distinctions. It says that there are three aspects. One is discussion, second is advocacy, and third is incitement. And let's not confuse the three. That's what the Supreme Court says. And I think that's the test we should apply to everything.
Thank you very much. No, we don't have much time. No, I'm sorry. I'm given a time frame, and that's why we finished it now. Thank you very much.
Thank you.